Good morning, Ms. Carlson. This is Judge Mata's courtroom assistant. Can I have you verify who you're representing today?
Yes, Kara Carlson for the Secretary of State.
Thank you very much. Good morning, Mr. Aerosmith. This is Judge Mata's courtroom assistant. Can you hear me okay?
Yes, I can.
Thank you.
Karen, Nate, I don't think I said good morning to you both yet, but good morning to you both. We have to stop running into each other like this.
Hey, that's
Well, I think
entirely up to you.
I was about to say, I think that's entirely
It
your
often
hands.
is. Fair point, Nate. Fair point.
It's all your fault, Brennan.
I know it. You just ask my wife. It usually is. And you know what? In her case, actually, that's a fair assessment most of the time.
Smart man to fall on your sword.
Oh, I have to. She has been probably God's greatest gift to me, and even if, the 1 out of every 100 times where it's like I think I'm right here, it's like, meh, well, with the other 99, I'm just gonna eat this one.
Is it worth it?
Right. Are you guys keeping your head above water? I'm sure you're just dying for the 20th to hopefully have these all resolved and take a little breath before the general.
To the parties, have we spoken to Mr. Barton, and do we know if he planned to attend this morning?
I have not spoken to him, but I know that he is in trial in Judge McDowell's division this morning.
Okay.
So I'm fairly certain he's not
Okay, thank you.
appearing.
Good morning, everyone. This is the time that we have set in CV 2026-030860. Appearances, please.
Morning, Your Honor. Brennan Bowen on behalf of Plaintiffs Arizona Free Enterprise Club and Darrell Groves.
Morning.
Good morning, Your Honor. Kara Carlson, representing the Arizona Secretary of State, Adrian Fontes.
Good morning.
Good morning, Your Honor. Nathan Arrowsmith on behalf of Attorney General Chris Mays.
Good morning. All right, this is the time that we have set for oral argument. The court did consider the plaintiff's verified special action complaint, defendant's joint opening brief, the plaintiff's opening brief, amicus brief provided by the committee who sponsored Proposition 212, plaintiff's response brief, and defendant's joint response brief. So how this will break down today is each side will be given 30 minutes. I will do my best, if I can, not to interrupt anybody's train of thought. That isn't the way I like for these things to go. But if I have an issue that I really need some clarification on, I will. Is there anything we need to do administratively before we get started?
I don't believe so for plaintiffs, Your Honor.
No, Your Honor.
Agreed.
Okay. All right, counsel, when you're ready, you can begin.
Thank you, Your Honor, and always happy to be interrupted by the bench. I think actually there's a fair amount, for all the disagreement, there's a fair amount of agreement here on the governing legal standard, and so I want to start there. I think we all agree that the language has to be reasonable, necessary info, and the secretary's attempt to comply with that, and not false or misleading. Both parts, it's a conjunctive test. That second part, I think, is perhaps where we get a little bit of disagreement, and this is coming from the quality education case, where the court did say that the specific statute at issue here, section 19-125D, does not require a, quote, impartial analysis, which is true. But the court also, in that case, quoting an earlier case, Howe, that also dealt with 19-125, and then was reiterated again in Lane, did note that ballot language also cannot be misleading, inaccurate. That would be the false or misleading, lacking in neutrality or argumentative. That's highlighted in Lane, who's quoting quality education, who's quoting Howe. So this has existed for the entire progeny, or Howe and its progeny, that not only is it false or misleading, but neutrality and argumentative are a part of it as well. Now, it is admittedly unhelpful for guidance from the court. What the difference is between impartial and neutrality is, I think, a tough line for courts to draw. But I think here it will not require a super tough threading of the needle, because ultimately there's two things that the state is tasked with doing here under 19125D. That is, for the title requirement, they must include all principal provisions. And then for the yes/no language, the description describing the effect of a yes vote or a no vote, that must include the essential change in existing law. And that is what plaintiffs are here focusing on, those two requirements today. I know there's 5 different categories, or I guess items, we've identified in the ballot language. And I also would like to be clear from the start, in the event that the court is inclined to rule for plaintiffs, the remedy we are seeking. We are not seeking the court to take our language, rubber stamp it, and mandate that the secretary do that. I actually don't. I agree with, if that's what we were asking, I agree that may not even be in the court's power to grant. What we're asking for is an injunction against any language that is false or misleading, or that doesn't include the principal provisions or in the title, or the essential changes in the yes/no vote. And then as far as the mandamus part, it would be mandating that the secretary and AG comply with 125D and draft language that includes whatever provisions the court ultimately determines are principal, or the changes in the law that the court determines are essential here. So we're not trying to take the pen away from the elected branches of government and hand it to the judiciary. With that point made, I'll go turn to each of the 5 different areas, starting with the section 13 of Prop 212. And forgive me, Your Honor, if I conflate it with 211. There was also a lot of litigation around Prop 211. I do mean Prop 212 for the entirety of what I'm saying here today. So section 13 is, in our reading of the text, a grant to the political committee that sponsored this, a private right of action to intervene, to initiate enforcement. Just looking at the plain text of it, it does say initiate and it does say enforce. And I get that the committee would rather it be construed more favorably to them, or they say it doesn't do that, but whether they intended it to do that or not, the plain language of the law clearly provides that that is what is being done. And even the state has conceded in its briefing that it's an open question. Now, I would put forward that I think it's the state's job to determine and answer that question as best it can, because it needs to know whether this is a principal provision or an essential change in existing law. And the committee is half right when they say, hey, provisions like this are frequently included in initiative and referendum. Sort of. Provisions that grant committees standing to defend the law if it's challenged either pre or post-election certainly exist very frequently. Even I think we highlighted an example from the Voters' Right to Know Act from last election cycle, gave its committee that authority, and that happens quite frequently. But this other language about initiating enforcements is not frequently included. I can't say definitively that it's never been done. I'm not aware of one. And so it does grant a private political committee the ability to sue the same schools and families that the ESA serves to protect. And so that's a fairly novel change in law, and one that is significant, especially when coupled with the next 2 changes, which I will discuss, which are the repeal of the ban on state control for private homes, was I'll say non-public education, as well as the removal of the state's current litigation burden under 152404. So first, the current ban is, categorical for non-public education, and we've covered that in the briefing. This Prop 212 would amend that to allow for schools accepting, or private homeschool families accepting ESA monies, to then be brought under state supervision and control. I get that the state has argued that the word control is charged, but I believe that's the exact word that the statute uses. And so removing that when there's currently a categorical prohibition is at least an essential change in existing law. We've also, argued that it is a principal provision, but I'm fully aware that, if we're all these construed as principal provisions, the secretary may actually not be able to contain everything in the 50 words of the title requirement, but the yes/no language, which is only required to state the essential changes, does not have that requirement. And all those spaces at a premium, so is complying with the law, and the things that are essential changes in law must be accurately conveyed to the voters. That is coupled with, at the same time that's happening, repeal of the state's current litigation burden to justify that it's reasonably necessary when the laws and regulations around ESAs are challenged in court. So at the same time that the initiative is granting a political action committee power to sue families and schools, it is removing the litigation burden to challenge those laws, and also giving new control over non-public education to the state, which is all in the backdrop of something else that the initiative does, which is an 8-month reduction in the regulatory requirements for promulgating rules under this act. So the net effect of these changes is a massive sea change in current education, non-public education specifically, and none of it's mentioned in the ballot language. Voters, I think, would be a little bit more keen to know that that Prop 212 does those things than whether it requires a fingerprint clearance card for a tutor. One of those seems to be a much more significant change in existing law, of which voters should be aware when voting on the initiative. Turning to the adjusted for inflation, we've discussed this quite a bit at length and given some examples practically how this happens, but all the parties agree the actual ballot language is adjusted for inflation at 2% or less, or depending on, you define inflation by the price deflator, and if it is below 2%, then we will match whatever inflation is for that year. So if it's, for example, 1.5%, the $150,000 cap will be adjusted by 1.5%. But any year that it goes above 2%, 2% is the cap. So if inflation was at 7%, 5%, we're not getting more than 2%. So the actual effect of that is going to be a one-way ratchet. As we noted in our brief, in 5 of the last 5 years, inflation has been above 2%. So each year, the net effect would be families losing ground in real dollars for what they can buy and purchase. And assuming that their salaries simply track with inflation, the effect over time will be that the pool of potential ESA recipients shrinks and shrinks and shrinks. That cannot be described as adjusting for inflation. It is, in fact, guaranteed that over time, unless inflation never exceeds 2% again, which current historical trends do not indicate is going to be the case, it will not be that it adjusts for inflation over time. It will have the opposite effect. Adjust for inflation suggests that, hey, families, I know we've set this line right at $150,000, and you're wondering, well, what if inflation eats away with that? Don't worry. The line, even if the number changes, will effectively be the same because we will adjust for inflation over time, when the actual result is we cannot possibly keep pace with inflation over time. It's a one-way ratchet. It can always give you less than what inflation is. It can never give you more than what inflation is. Finally, turning to the school voucher program, I think we all agree that this is a contested label under Arizona law. And as we've acknowledged in our response brief, we're not saying that the Niehaus case creates a categorical distinctions between vouchers or ESAs. It never says ESAs are not vouchers. What it does do is highlight the previous case of Kane, where 2 voucher programs were struck down under a similar challenge, and distinguish the ESA's mechanism and explaining why it is constitutional. So that distinction in the law makes this, at best, a contested definition in the law. It's also, as we noted, and as the Arizona legislature noted in its letter to the state, nowhere in Arizona's current ESA statutes is the word voucher used. And in the initiative itself, it's only used in the findings and declaration of purpose section, the one section without really any legal effect or not codifying and changing new statutes and amending old ones. And so neither before or after is voucher going to be a part of the operative ESA statute. So there really is no reason to include the language here. And the legislature specifically warned in its letter to the state that it's a politically charged term and it shouldn't be used. This is again going to that non-neutrality issue that we've talked about from Lane, which cites its origins and how and was repeated in quality education. There is no reason to include it. It's not an essential change in existing law because it doesn't create that as a defined term. It doesn't call the program that. And even the initiative, when it uses it, hedges in their declaration and purpose section with so-called, and noting that this is perhaps a colloquial usage, but this is not a legal definition. But the state's job here is to provide for the change in law, not what is commonly understood as. And even if others colloquially use that term, in newspapers or think tanks, they are not under the same duty that the state is here. And so it shouldn't be added. And I'll also note in response to the letter that the legislature had sent, the initial language only included school voucher program with the effect of a no vote. It was ESA school voucher program after that. It wasn't included in the language for the yes vote. And then the legislature flagged that this is politically charged and shouldn't be used and isn't used in the statutes or initiative in any meaningful way. And then the Secretary and AG's ultimate ballot language actually added it into the yes section where it did not previously exist. So that the state says it's politically charged and the response was to include it elsewhere. That certainly seems to be the lacking of neutrality that Lane prohibits. With that, Your Honor, I will reserve the remainder of my time for rebuttal or answer any questions that the court has.
All right. So that I'm clear, one of the things that I'm trying to understand is this oversight that you have all talked at length about. Is it the plaintiff's perspective that essentially creates like a regulatory agency or something different?
Could the court clarify what it means by oversight? Like the state control, what we've categorized as the state control of non-public education? Correct.
So if there's oversight now in private schools or home schools by members of the committee, are you making that analogous to like a regulatory agency, or what is the objection to that?
Oh, as far as the committee being granted a private right of action to sue?
Correct.
Correct. We are not contending that the committee would be a new regulatory agency, and it's certainly going to how the committee intends to go about their newfound power to initiate or intervene in enforcement actions. I'm not sure. They obviously don't have the same resources as the government. Our contention is only that it gives them the standing to do so in more than just defending the law, right? The normal standard here for initiatives is if someone sues to have a law declared unconstitutional and you're the committee who sponsored that law, you get to go defend it. But this goes beyond that. It says that the committee can now start enforcement action. So if the committee gets wind of something that it perceives as a violation, it can sue the participating school or homeschool family to try to enforce the law. I don't think that's necessarily the creation of a new agency. It's just the granting of a private right of action that doesn't exist to them currently. Enforcement power is the job of the Attorney General. And the statute does also provide that the Attorney General is tasked with enforcing that, but it simultaneously grants that power to the committee.
I see. Okay. And one of the issues that they talked about were the luxury items. So this is probably a question for both sides. Is that allowed right now?
My understanding is it's not, but I know the AG's office has done a lot more with enforcement and trying to crack down on folks who are using things for non-educational purposes. My understanding is the statute currently does not permit spending for non-educational purposes. And from what I understand of the committee, though I won't speak for them, the intent behind this was to tighten the noose on that, so to speak. Like, you need to be spending for things actually related to education, not for luxury items. But I can also defer to the state to answer that.
Okay, thank you. All right, so I assume that both of our defense attorneys have divided up the time how they see fit. So when you're ready, please proceed.
Yes, Your Honor. We have provided a lot about the legal standard in our briefs. So what I think might be most helpful to the court is to take a step back from that. Yes, we agree that the standard is not false nor clearly misleading. It is also not impartial. Impartiality is the language in ARS 19124 that governs the Ledge Counsel analysis, that is not printed on the ballot and accordingly is not limited or subject to any length restriction. Neither the 50-word limit for the title description nor the brief description limit for the rest of the ballot language. So we know that titles are only 50 words. We know that brief offers some flexibility, but it carries its own inherent limits to address the concerns that voters and elections officials have. So the brief description is printed on the ballot itself. This year, there were 11 ballot measures that have made it to the point where we have to do the ballot language and engage in this process and the expedited litigation. At most recent count, I believe at least 8 of those measures will be included on the ballot. Whether Prop 212 will be on the ballot is currently an open question being determined by another division as we speak. But needless to say, it's a significant number of ballot measures that will appear on the ballot, occupying a significant amount of ballot real estate. Now, the actual language of this measure spans 10 full pages of single-space text. Choices must be made as to what is a primary purpose rather than secondary, and what is an essential change to existing law rather than non-essential. The primary purpose and essential change must fit either into the 50 words or a brief description according to ARS 19125D. Now, we are, if something is undefined in statute, brief is not defined. You can turn to a dictionary. Merriam-Webster defines brief as short in duration, extent, or length, or concise. When the ballot language was being drafted for this and the 11 other measures, the secretary and the counties were concerned that the length of these descriptions, along with every other race that's going to be on the ballot, which includes federal, state, local, nonpartisan, judges, possible local questions depending on your jurisdiction, could bump ballots from 1 to 2 pages or from 2 to 3 pages, depending on the county. Now, increasing ballot length has systemic impacts. It significantly increases costs and burdens on the entire system. Hence, ARS 19125D's brevity requirement. The increase in county expenses comes across many different layers. Ballot printing, the cost of ballot paper, the postage for voters to receive ballots and return them. All of those are county costs that would increase as the length of the ballot increases. It increases the complexity in election administration for in-person voting and tabulation. For example, it takes twice as long, obviously, to tabulate a 2-page ballot than a single-page ballot. When a county like Maricopa is running more than 1 million ballots, that's a significant amount of time, even with the fast and accurate tabulators that the county has. Longer ballots also increase the time and logistical challenges for the hand count audit process, which is necessary to ensure the accuracy of the results. And longer ballots also make the final canvassing of results more complicated because the numbers of voters who signed in and the number of votes cast must be accounted for and balanced in a very, very short time window to certify the results. And the longer the ballot, the more voter fatigue sets in, longer lines become an issue. I mean, it is just a systemic, multiple issues have to be considered when you are looking at what is brief. What is a brief description that includes the primary purpose and the essential changes in the law? So while brief description, as plaintiffs note, is not a hard cap on the word limit like what we see in other areas of the law, it still imposes a requirement that the ballot language itself for each provision is actually brief. Plaintiffs' suggested language, and we recognize that they are not saying rubber stamp the language, but viewing it as this is what plaintiffs would prefer, would double the length of the brief description from half a page to a full page. And you can compare and that's just for the ballot language. That's just for the ballot language, just for this provision. And you can see that by comparing the complaint at page 7 with the complaint at page 11. So that gives you the bigger picture of the things that the Secretary of State and Attorney General must consider when developing the ballot language and how to comply with the mandates of ARS 19125D and the requirements under quality education that it be not false or clearly misleading. Now, plaintiffs here said how also dealt with 19125. That's true on its face. However, it is important to note the context. So how only said that the Secretary's ballot language survived because the more specific requirements of the alleged counsel language was sufficient. So how only analyzed ARS 19125D in a single paragraph at the